Hello everyone, myself Maneet Kaur, Assistant Professor, School of Law, City University, Ludhiana. I am about to present emergency provisions under the Constitution of India. So we'll be discussing about the concept of emergency provisions. We'll be discussing about the grounds of the declaration of this emergency, and another thing we'll be discussing the procedure as to how this emergency is to be approved. Lastly, we'll talk about the effects of emergency, like on center state relations, or the effect of the emergency on the fundamental rights. So, starting with the introduction of the emergency provisions, these are provided under Part 18 of the Constitution, that is under Article 352 to 360 of the Constitution. The purpose of providing this emergency provision is to enable the central government to deal with certain difficult or the situations which are not normal in the country in an effective manner, like when the security or integrity of the country is threatened. In that case, the emergency provisions play a very fundamental role. Since the security or the integrity or sovereignty of the country, it is a fundamental and the most important thing which is required to be protected. So in that case, the other functions, they will take a back seat. That is, all the other decision making functions, they will take a back seat, and the first and the foremost important thing which is required to be done is the protection of the sovereignty or security of the country. So there are three kinds of emergency which are provided: national emergency, state emergency, and financial emergency. Article 352 of the Constitution, it talks about national emergency. There are three grounds: war, external aggression, armed rebellion. The first and second one, that is war and external aggression, it comes under the category of external emergency, and the third one, that is armed rebellion, it comes under the category of internal emergency. So this emergency, it can be declared when there is the actual occurrence of war or external aggression, or even if there is any imminent danger, that is, if actually the war has not occurred but there is a threat of that kind of situation, that such kind of situation may arise. So in that case also, this national emergency can be declared. So after this, the proclamation of national emergency, it can be done to the entire country or to a part of it, which means that whatever the to the part of the country, for example, that if the northeast area of the country, it receives war threats, so in that case, in that northeast area also, this emergency could be declared, so to the entire country or to the part of the country. So this was by way of 42nd amendment, which enabled the limited operation of the emergency, that is to the certain part of the country only. So earlier the ground of internal disturbance was provided. As I mentioned the grounds, I talked about war, external aggression, and armed rebellion. I did not say internal disturbance, but this ground was earlier provided. Later on, by way of 44th amendment, this ground was changed, and now it is armed rebellion which is provided. If we talk about the emergency, national emergency, in India it has been declared three times: in 1962 when there was a war, India-China war; in 1971 India-Pakistan war; and third one 1975. 1975 emergency is also called as the darkest phase of Indian democracy. Reason being, at that time Prime Minister Indira Gandhi, she declared the emergency. She advised the emergency. She advised the president that it should be declared, and the emergency was declared by the president later on, and no recommendation of the cabinet was obtained, and that phase is known as the darkest phase. Reason being, that kind of period, the emergency which was declared for certain political reasons also, so it was a kind of a controversial emergency, and so as to avoid any kind of misuse later on also, 44th amendment was brought, and it introduced certain changes. One of the change was that written recommendation from the cabinet is required, and since the internal disturbance ground, it was also removed, Reason was that in the term internal disturbance, it was considered very vague, it was considered very unclear, as it did not clearly indicate as to what are the circumstances in which the emergency could be declared. So in that case also, that was the reason why the internal disturbance ground was changed. So because it was not clear, it was vague. And another thing which was added by 44th amendment was written recommendation from the cabinet is required. Prime Minister Indira Gandhi, she advised the president to declare the emergency. No cabinet was not consulted, no recommendation from the cabinet was obtained. Rather, the situation was of such a kind that after the emergency was issued, after it was proclaimed, the cabinet was informed later on. So that is why the constitutional safeguards were provided by the 44th amendment. The constitutional safeguards were provided so as to avoid any misuse, any abuse of powers at the hands of the executive, that they do not go on advising the president to declare the emergency for any other reason which is not actually suitable at that time. So after the emergency is issued, it is required to be approved within 1 month from the issue. Earlier the period was 2 months which was provided, but it was reduced to 1 month. And if the proclamation it is issued at the time when the Lok Sabha is dissolved, or the dissolution of the Lok Sabha, it takes place during the period of 1 month without the approval of the proclamation, then in that case the proclamation will survive until 30 days from the first sitting of Lok Sabha. But in that case, Rajya Sabha should have approved that emergency in the meantime. Next is that once it is approved, then it will continue for 6 months. That is, approval is there for 6 months, and after that it can continue indefinitely. However, the 6 months periodic approval is must, it is required. Periodic parliamentary approval was not earlier provided, it was provided later on, that after every 6 months approval is required to be obtained from both the houses of the parliament for the continuation of the emergency. Earlier, once the emergency was issued, it was approved, then it continued indefinitely. Now also it can continue indefinitely subject to the condition, and that condition is periodic approval from the parliament. And this emergency, it is required to be approved by both the houses by special majority. If we talk about the other emergency provisions, that is a state emergency or a financial emergency, in that case the approval is required by simple majority. But this national emergency, it requires approval by special majority, that is majority of total membership of the house and majority of not less than 2/3 of members which are present and voting. So this then after this, once the emergency it is approved, it is declared, there is a procedure also to revoke it. And how this revocation will take place? There are 3 ways of revocation. One is when the president it subsequently proclaims. It subsequently proclaims that yes, now there is no need of the continuation of the emergency. So in that case, after the subsequent proclamation of the president, this emergency it can cease to operate. It can revoke actually. Revocation is the actual key term. So no parliamentary approval is required in that case. For instance, if a war continued for 4 months and since the approval is for 6 months, so there is no fun of continuing the emergency for the remaining 2 months. So in that case, the president can pass the proclamation that no emergency should now operate further. Next is by the resolution of Lok Sabha, and this was introduced by 44th amendment. That is, earlier Lok Sabha it had no power, it had no control over this matter of revocation, but this was introduced by 44th amendment, that is resolution by Lok Sabha, that Lok Sabha can pass the resolution. And again this resolution by Lok Sabha, it can pass the resolution by simple majority, and that the emergency should be revoked. Next is the third way of revoking this proclamation of the national emergency is when 1/10 members of the Lok Sabha they give a written notice. They give a written notice to the speaker that in that case a special sitting will be held within the 14 days after that notice is given. For that, in that special sitting of the Lok Sabha, they'll discuss or they'll consider this matter of revocation. So in that way, resolution of disapproval is different from the resolution which approves the continuation of the proclamation. As far as the disapproval is concerned, as I said in the earlier slide, that it is resolution by Lok Sabha which is required. But if we talk about the approval, we talked about that by both the houses of the parliament, by the special majority, it is required to be approved. So resolution of disapproval in that way is different, as here only disapproval by Lok Sabha is required, whereas in that case when it is required to be approved by both the houses. And the second major difference is when the approval is required to be obtained, it is by way of special majority, but in case of the disapproval, it is by way of simple majority. Next is the effects of national emergency. One is it affects center-state relations. Second is it has an effect on the life of Lok Sabha and State Assembly. And third one is that it has the effect on the fundamental rights. So starting with the effect on the center-state relations. Now what happens is that in the normal circumstances, center can give directions to the state only in certain specified matters. But when this national emergency is in operation, then it can give directions to the state on any matter. So this is how the relations change between center and state during the period of national emergency. Secondly, legislative relations. That parliament, it can make law even on that subject which is mentioned in state list. Otherwise, in normal circumstances, in the on the subjects mentioned in state list, the state has a power to make law. But when this emergency is in operation, then the parliament becomes empowered to make laws also on those subjects which are there in the state list. And these laws which are made by the parliament on the subjects which are mentioned in the state list during the national emergency, they will become inoperative 6 months after the emergency has ceased to operate. Thirdly, financial relations. That the president, it can modify the distribution of the finances and revenue between the center and the state. So this is how the center-state relations are affected. Second is it has effect on the life of Lok Sabha and State Assembly. That is when the proclamation of national emergency is in operation, then the life of Lok Sabha, which normally it is 5 years, it can be extended for 1 year. But this extension, it cannot go beyond 6 months after the emergency is not in operation, that is it has ceased to operate. So the life of Lok Sabha, it can be extended for a period of 1 year at a time. Next is the effect on the fundamental rights. So in that aspect, Article 358 and 359 are very significant. Article 358, it says that once the national emergency is in operation, there is automatic suspension of Article 19. So all the fundamental freedoms which are enunciated under Article 19, they are automatically suspended. Automatic suspension means no separate order is required to be passed for the suspension of Article 19. Once it is in national emergency is in operation, there is automatic suspension of Article 19. And if we talk about Article 359, in that case there is a suspension not of the fundamental rights, but there is a suspension of the right to move to the court for the grant of for the enforcement of fundamental rights. So theoretically suspension does not exist of the fundamental rights in that case, but if we talk about the practical scenario, the right to move to the court is affected for the enforcement, that in very much manner it will affect the fundamental rights, but it is the right to move to the court which will say is affected in that case. And Article 20 and 21, they are not suspended in any case. In case of Article 358, that is suspension of Article 19, it takes place in case of external emergency only, that is war and external aggression. So it does not take place in case of the internal emergency. But if we talk about Article 359, it takes place in case of both external as well as internal emergency. And in case of Article 359, the right to move to the court for the grant of for the enforcement of the fundamental rights, it is affected by way of presidential order. So presidential order holds a very significant and a dominant position in that case, because it is by way of presidential order that everything will be decided, that for what duration, that for what area which is specified in the presidential order, which will be affected. So the major difference which lies is the automatic suspension, that in one case there is automatic suspension, and in the another case there is a presidential order which plays a major role. And further, if we talk about the next we have is state emergency. The ground for state emergency, they are mentioned under Article 355, under Article 356 and under Article 365. Now center, it has a duty. It has a duty to protect the state from any sort of internal disturbance, from any external aggression. Apart from it, it also has a duty to see that the government of the state is being carried on in accordance with the provisions of the constitution. So this, by virtue of this duty, this state emergency comes into play. That is, if the government of the state is not carried on in accordance with the provisions of the constitution, then in that case the governor can report to the president that this kind of situation is occurring, or there is some sort of difficulty which is arising. So in that case the governor can report, and after the governor reports, accordingly this emergency, it can be declared. Another thing is that it is not by way of report of the governor, but on the other cases, that is, otherwise also the president feels that the government of the state is not being carried on in accordance with the provisions of the constitution. So in that case also, that is not on the report, but otherwise also it can declare this emergency. Next is Article 365. That is, if the state, it fails to abide by the directions of the center, in that case also this state emergency can be declared. And as the terms are mentioned here, constitutional emergency, state emergency, president's rule, these are the different names for this. Constitutional emergency, it is called so, reason being that it is related with the case when the government of the state is not carried in accordance with the provisions of the constitution. See, every state has to act according to the provisions of the constitution, that it is by way of constitution that they are deriving their power, they are deriving their existence, and that is why they have to work in accordance with that. And when they are not working in accordance with that, then that is, the center will have a check upon it, and accordingly the provision of state emergency has been embodied to keep a check or to regulate this kind of thing. So next is that once this emergency, the state emergency, it is issued, then within 2 months from the issue, by both the houses of the parliament, it is required to be approved by the simple majority. So once it is approved, it will continue for 6 months, and the maximum period is 3 years. That is, after 3 years state emergency cannot continue. And one more condition is there, that if after 6 months approval is sought, then again after 6 months approval is sought, so after 1 year. Now after 1 year, if again continuation is required, then in that case 44th amendment has restrained the power of parliament to extend the president's rule beyond 1 year. That is, beyond 1 year the extension is subject to 2 conditions. One is a proclamation of national emergency is in operation, and secondly, if the election commission certifies that the elections can be held in the state in the legislative assembly. So in that case only beyond 1 year this extension can be granted, otherwise no extension can be granted beyond 1 year. So what are the consequences which take place? Firstly, the legislative and the executive functions, they are affected in the way that now the president, it can take the functions of the state government as well, and also whatever the powers of the state legislature are there, they are to be exercised by parliament. President can declare this thing, that whatever the functions, the powers of the state legislature are there, they will be exercised by the parliament now. Another major thing which happens is that the state council of ministers, it is dismissed, and the administration of the state is carried by the governor. Also, if it is felt that the legislative assembly is to be suspended or dissolved, accordingly it will be seen whether it is required to be suspended or dissolved. Accordingly, such an order is passed. Next kind of emergency, the last is financial emergency. This emergency is dealt under Article 360 of the Constitution, and the ground for declaring this financial emergency is that if there is any sort of financial instability in the country or the credit of the country is threatened, so in that case this financial emergency can be declared. Now earlier what happened, that once this emergency was declared by the president, then the satisfaction of the president was considered final. It was not questionable. But by way of 44th amendment, the safeguard was introduced. The safeguard was that it is subject to judicial review, that the satisfaction of the president, it can be subjected to judicial review. So once again it is issued, within 2 months it is required to be approved by way of simple majority. And this financial emergency, it goes on to operate indefinitely until it is revoked. That is, no repeated approval is required, and the revocation is also a very simple process here. That is, any time it could be done and no approval is required. As in the other cases, the revocation methods were different, but here the revocation method is again very simple one. The last thing is that the effects of the financial emergency. So if we talk about the effects of the financial emergency, in that case the effects are that whatever the state, they can be directions can be given to the state to see how the finances or the expenditures are to be done. And another thing is, the other directions could also be passed to the state. Since it is the entire credit of the country which is being affected, in that case even in the other directions they can reduce the salaries of the employees, even of the judges of the high court. So accordingly, if the such kind of situation arises, then that reduction of salaries could also be done. And also the money bills that could be reserved for the consideration of the president. So that was all about the effects of financial emergency. So I hope that all the grounds and everything, they are clear, and that was all about the 3 kinds of emergency, the grounds, effects they later on ensue, or the consequences of the declaration of the emergency. So thank you everyone.